understand it. What is so special in law when you use this word relatable?
Paragraph.
Well, not para 25.
It's all part of compilation.
Avaru kottidira copy?
Yes.
Four propositions emerge very clearly from the authorities discussed above. 1. Whether a given dispute inclusive of the arbitrator's jurisdiction within the scope of the purview of an arbitration clause or not primarily depends upon the terms of the clause itself is a question of what the parties intend to provide and what language they employ. 2. Expressions such as arising out of, or in respect of, or in connection with, or in relation to, or in consequence of, or concerning, or relating to the contract are of widest amplitude and content and include even questions as to the existence, validity, and scope of the arbitration agreement. Now, my lord, I'm only the first portion of it. It is of widest amplitude. Otherwise, my lord, I ask myself the question, why did the legislature use the word relatable to? They could simply have used, without that word, the section could have made sense. It is, did you play a role in relation to that recommendation or decision? Is a question. And the role could be minuscule. Even then, the act applies.
Needle of suspicion.
Needle of suspicion. Needle of suspicion, my lord, is the crux of the matter, is what I would submit your lordship for consideration. Now, my lord, another aspect, my lord, I want to take your lordship through the index, my lord, so your lordships get an idea as to what is this, what is it that we are, and if there is any particular aspect on which, my lord, I think is necessary, and if your lordship permit me for me to dilate, I will do it.
163, the Solicitor General has relied on. Same judgments.
Well, yes, and I want to point out only one thing, my lord. In what was told to your lordship by the petitioner was that the law laid down in MP special police establishment case has been watered down.
No, that is clarified.
So therefore, I will not. Very well. But that's why, my lord,
Nawab Rabia went on a different footing.
No, in fact, Nawab Rabia says that affirms it. On the contrary, my lord, without diluting, what was told to your lordships by the petitioners was that the judgment of the Supreme Court in Nawab Rabia has diluted the law laid down in MP.
No, that submission was diluted.
I will not object.
Yes.
Now, my lord, your lordships may kindly look at. There is one judgment, my lord, which possibly will have a bearing to a certain extent at the present stage
On what?
on discretionary powers of the government. And then your lordship gets Antul's case, my lord.
Huh.
Antul's case, my lord, seems to suggest that the power of the court under 156(3) is not trampled by 17A. Though 17A was not there.
17 was not there.
I done that, and I am aware.
5A of the old act.
The old provision, my lord, they were considering that. 17A was not there. 17A
No,
was
17 is 2018. What was considered was not even section 19.
No.
It was under the old
Old
act.
Act, 5A.
What was sanctioned in
5A.
that is Abdul Rahman Antul's
5A.
case.
5A.
Yes.
So even there, the question, my lord, is as to whether the power of the court under 156(3) is circumscribed by the requirement of a permission. And the view, as I understand in Antul's case, my lord, is that the power of the court is not taken away. And I'm given to understand, my lord, that question is pending before a larger bench. In any event, my lord, that may be a little premature to be discussed in this proceeding today. Because we are looking at, now, my lord, your lordship may kindly look at what we have now placed for your lordship consideration, my lord, is section 17A has been considered, my lord, in Yashwant Sinha's case.
That's the beginning.
That's the beginning.
The first judgment on 17.
Exactly. We have put all that, my lord, so that it's all in one place. And then, my lord, there is another submission that I want to make. Yeah. My lord, there are two situations. One is absence of sanction. The other, my lord, is invalidity of sanction. Now, can the question of invalidity of sanction be taken up before the special court?
See, that is one point where sanction is accorded, invalidity of sanction or otherwise in normal circumstances. Now the issue is sanction is accorded by a constitutional authority. That cannot be taken there. Therefore, the validity of that sanction, whether it bears application of mind, it is needed or otherwise, is only by this court. That cannot, the Court of Session cannot sit and scrutinize what the governor has said, whether he has applied his mind, he has done that, he has done this. No. This court is.
that distinction that your lordships are putting to me between a sanction that is accorded by
You began the submission saying that this is governor's sanction, high functionary's sanction. It is not like a Tahsildar issuing
Yes.
sanction. The same thing applies here also.
Now, that submission was made, but not in the context of the fact as to what is the extent of judicial
Examination.
examination.
See, that is why
That purpose.
the extent of examination, if that is so, that we are not examining the order of a Tahsildar, but we are examining the order of the governor of the state sanctioning or approving whatever is to be done against the chief minister of the state, then it's not that the court will scrutinize whether governor has applied his mind or not. It's constitutional court will do it.
I'm not saying the constitutional court cannot. I'm saying, is it
There's
the case?
nothing that this court cannot.
Exactly.
Yes.
There's nothing that this court cannot. In
See,
fact,
anything before this court is maintainable,
Exactly.
whether it is entertainable or
that is
not.
the
it
point, my lord.
discretion.
That is exactly what the Honorable Supreme Court also has said, my lord, the recent judgment in
Yes.
Godrej Sarali.
Yes.
Supreme Court has said the question when a writ petition is filed is not as to whether writ is maintainable. The
Every
question
petition is maintainable,
every
whether it is entertainable
Exactly,
or
my
not.
lord.
It is the discretion of the
Exactly.
court.
Now, in a situation of this kind, now just look at what the Honorable Supreme Court has said, my lord, in 2020. Please be kind enough to turn to page 607.
No, it can be decided during the course of trial is what is
Exactly.
said.
Yes. Now, if you
1 minute. Validity in that judgment was qua the competent authority. Whether the competent authority had accorded sanction or not, that can be decided there. No problem. Here, that is not the question of competent authority here. Here, it is the question of sanction being accorded by the governor to granting approval. Even sanction is said in that. So I can say granting sanction for prosecuting the chief minister. That cannot be. That I don't agree.
But the proposition seems to be a little wider than what your lordships have put to me. That it is only the power or who is the sanctioning authority which can be got into at the time of trial and not otherwise. But not the
No,
proposition
validity, qua the competence. See, now it is the managing director of a particular organization who is the competent authority declared to grant sanction. Somebody else has granted. That can be debated before the concerned court at the time of trial at any stage of the trial. That's a different thing. Whether here application of mind is there for the purpose of grant of sanction or otherwise, qua these people, yes, is triable here. And merely because it is to be considered during the trial, it would not lock the hands of this court to consider it.
But I don't think I'm going to canvass that proposition at all. 226 jurisdiction, my lord, is unlimited. It is only self-regulatory, self-discipline, etc., etc.
So we'll
there,
do that.
but in the facts of a given case where
I will answer that because that is also submitted.
Okay.
I will answer that.
But that just for reference, my lord, we are given the judgment of His Lordship Justice Bopanna as it then was at page 607.
Yes.
Parallel basic.
I'm not sure whether this was showed to your lordships.
No, with Justice Bopanna or the
Yes.
page.
My lord, page 607. My lord, the relevant portion is at page 613. My lord, may I trouble your lordships to kindly see the facts at para number 2. It seems to lay down a slightly broader proposition than what your lordships put to me.
Yes.
My lord, please now be kind enough to turn
Para 11.
paragraph number 11.
Yes.
Yes. Further, the issue relating to the validity of the sanction for prosecution could have been considered only during trial, since essentially the conclusion reached by the High Court is with regard to the defective sanction, since according to the High Court, the procedure of providing opportunity for explanation
Yes.
was not followed,
Those things
which will
can.
result in the sanction being defective.
No problem.
Next sentence, my lord. In that regard, the decision in Dinesh Kumar relied upon by the Additional Solicitor General would be relevant, since it is held therein that there is a distinction between absence of sanction and the alleged invalidity on account of non-application of mind. The absence of sanction, no doubt, can be agitated at the threshold, but the invalidity of sanction is to be raised during the trial. In the instant case, admittedly there is sanction, though the accused seek to pick holes in the manner the sanction has been granted and to claim that the same is defective, which is a matter to be considered in the trial. So, my lord, on this,
We have not yet reached sanction. We are at approval threshold.
yes, my lord, but it doesn't really bear any difference.
Difference? No, no, no.
It doesn't
See,
bear any
sanction is post-investigation.
Yes, it is different stages.
No, the
is
sanction is
different
post, between 17 and 19, what happens is investigation.
Absolutely.
Abundant material to seek sanction to prosecute.
Absolutely.
Now, there is prima facie material, needle of suspicion in 17A.
Yes, needless suspicion. No, I'm only saying, my lord, only for this purpose. If you can raise the correctness of a sanction under 19, even 17A is a matter that can be raised there. So, my lord, I would say, my lord, that this principle should be extended there also. That's a submission I'm making, my lord, because I believe, my lord, Dinesh Kumar also says the same thing.
Yes.
And then, my lord, your lordship may kindly look at the next proposition.
Yes.
Sanction is an administrative order, my lord.
That
I
is-
think it's
that
already
is-
been, we have, my lord, I'm conscious that it has been told to your lordships. We are just giving your lordships all the material in order to
And these judgments are also
assist,
given.
in order to assist your
Yes,
lordships in
yes.
writing the judgment, my lord. That's all. Then, my lord, Commission of Inquiry, what is the scope? It's just a report, and my lord, the Supreme Court.
No, it
says
is only recommended.
the Supreme Court says it is unfortunate that most of the reports don't see the light of day.
Anyway, but it's recommendatory.
Yes, my lord, absolutely. And then, my lord, kindly turn to the next one. Next page. Complaint need not be a detailed complaint. My lord, your lordships are aware of that proposition. It need not be an encyclopedia. But what am I going to say as a complainant? I don't have all the material.
No, no, in fact, in this case, it is detailed.
In this case, we have written 5-6 pages, my lord, and single line spacing.
Single line spacing. Adnan Nodlilva. I did not look into that. Yes.
The complaint is in single line spacing.
Alright.
So much of material has been, so many
No,
facts.
it is in detail.
It is in detail. Therefore, my lord, we have given your lordship the 3 number 30 and
It is in
31.
detail. The complainant has appeared before the governor. The governor has heard him.
Not as my lord,
R3.
our
R3.
yes. And then, my lord, on this question of natural justice, I just want to point out, your lordships, how natural justice, my lord, is not some straitjacket formula. Kindly see, my lord, serial number 26. Ashok Kumar Sonkar's case.
All of them follow unruly horse.
Yes, unruly.
1977.
Unruly horse.
Ramji.
Yes.
Yes.
And it should not be a futile exercise. Now, my lord, let us, the complaint that I have filed and the complaint filed by Abraham are identically worded. Now, if you are given notice in one, what does it matter? And you have taken a decision in respect of one complaint which is identically worded, so far as I am concerned. What does it matter if my complaint is also referred to in the approval order? How does it affect the petitioner? Therefore, my lord, natural justice should always be coupled with prejudice. There is nothing like natural justice standing alone as a point without showing prejudice. And if prejudice is not shown, then, my lord, the plea that there is a technical breach of the principles of natural justice, even if one is to apply that, and I would maintain, my lord, that at the stage of 17A, there is no requirement. Contrast the language to 19. 19 requires
No,
that.
19
Requires that.
Statutory
17A is the same statute the lawmakers provide for hearing. In another provision, they don't. What is the necessary influence? That insofar as 17A is concerned, it is excluded. So, my lord, without prejudice to that submission that there is no requirement and all this notice that was sent by the governor was only by way of, I would say, my lord, abundant caution. It is only, my lord, to satisfy, maybe, my lord, some that unruly horse. Even
All
if it's.
right.
So, my lord, if that is so, my lord, the fact that the complaint filed by respondent number 4 was not supplied to the petitioner does not in any manner vitiate the order. And then, my lord, the meaning of the word, my lord, previous approval, we have set out 32 to 34, my lord. May not be so relevant, but for the because the words used is that. Anything else? My lord, I think, my lord, with this I have shown to your lordships all the facts and the law which I thought was relevant.
Thank
I'm
you,
grateful
sir.
to your lordships.
Thank you. Sir.
Anything else?
Wait, sir.
My lord, there's one
You-
small.
ಮತ್ತೆ ಸ್ಟೇಟ್ ಶೇಕ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಡಿ.
My lord, one small addition I want to make. Well, there is an interesting book on Kerron frauds. I want to show to your lordships one passage in that.
Fraud
Really?
and mistake.
No, I'm on fraud.
The book.
Ye book is it. Book is it. It is a both, my lord. It's a well
Yes.
recognized. Kindly see the first page, my lord.
First page.
Yes.
Page one.
Page 1. It says chapter 1 under the heading fraud. My lord, I have a slightly older edition. Maybe I don't know which edition your lordships have, but if
Ah.
your lordships. Fraud and mistake. Is that how it begins?
1 minute, sir. Ah,
Fraud and mistake as grounds of relief are alike founded on ignorance. Is that how it begins, my lord?
yes.
Yes. There can be no mistake where there is no ignorance. There can be no fraud where there is no mistake. It is not easy. This is the passage I want to rely upon, my lord. It is not easy to give a definition of what constitutes fraud in the extensive signification in which that term is understood by civil courts of justice. Courts have always avoided hampering themselves by defining or laying down as a general proposition what shall be held to constitute fraud. Fraud is infinite in variety. The fertility of man's invention in devising new schemes of fraud is so great that the courts have always declined to define it or to define undue influence, which is one of its many varieties, reserving to themselves the liberty to deal with it under whatever form it may present itself.
No, fraud has many hues and forms.
Hues and forms.
So
And then, of course, my lord,
it-
all that.
Every
No, my lord, I
every
thought-
case that comes up has a different hue.
And that's why, my lord, the author says, fraud is infinite in variety, and the fertility of man's invention in devising new schemes of fraud is so great, the courts have always declined to define it or to define undue influence, which is one of its many varieties, reserving to themselves the liberty to deal with it under whatever form it may
Yes.
present itself.
Well, okay.
Therefore, my lord, fraud, my lord, is never committed in daylight. It
It's
is
like-
always
It's like conspiracy.
always done undercover. And it is therefore, my lord, the responsibility of the courts to say, how do I read between the lines of an action to find out if there is fraud? It is a very difficult exercise. And there's one authority, my lord, that I want to show. With that, my lord, I shall not detain your lordships, my lord, only to say that higher the authority, my lord, 2004,
Higher the responsibility.
2000, no, and limited is the role of a court.
That is true. Yes, correct. That
Well, yes.
current SG has shown.
2004, I don't know whether this was shown to your lordships, Vikas Chatterjee's case.
I think so.
2004, 7 SCC
Sir, put it on, right?
634. Well,
I'll see if it is repeated. you will
repeat
ignore.
it better.
No
Repeat,
problem. No,
repeat and stop. Well,
you can read, sir.
kindly turn to paragraph number
This
10.
was shown. Yes.
It was shown to your
Yes.
lordships by para 10.
President of India's, I think. This.
Yes. Para 10. In the case of Maruram versus Union of India,
Pardon rejection. Yes.
and I will not.
Yes. Yes.
It's been shown, my lord. Great.
No.
You're empty-handed. ನೀವು ವಾಲ್ಯೂಮ್ ಕೊಡಿ.
ನಾವು ವಾಲ್ಯೂಮ್ ಕೊಡಲ್ಲ, ಅವ್ರ ವಾಲ್ಯೂಮ್ ರಿಲೈ ಮಾಡ್ತೀವಿ. ಒಳ್ಳೆ ಟೈಮ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀವಿ.
ಟೈಮ್ ಕೊಡಿ ನಾ ಅದು ಮಾತ್ರ ಕೇಳಬೇಡಿ. Finish your submission, sir.
Manoj, kindly have it on Monday, Manoj.
Why?
After that,
Next Monday.
yes, Manoj.
Why?
When Friday is a holiday, Manoj, I need to go in detail. Manoj, I'll make a synopsis and place it before your lordship.
Hello, what are you? The Advocate General state is.
No, Manoj, because submissions were made with regard to aid and advice and the opinion of the Advocate General and few aspects. As respondent,
Submissions were made about the fairness of the Advocate General.
no, that is one aspect, Manoj. It's a backhanded compliment. Therefore, I need to say certain aspects, Manoj, on
ಅದಕ್ಕೆ
163.
ಒಂದು ವಾರ ಬೇಕಾ?
Manoj, in fact, and again, Manoj, on 4th again.
So when is senior counsel completing now? Now that all the respondents have completed, you are neutral. That's why I'm saying all the respondents have completed. When is Singhvi sir completing?
Sir,
Sir,
I will, Malas, I will go after the AG. The reason is, Malas, that
Not
there
after
is,
me, Manoj, next. once I
after the submissions of the
submission
AG.
of-
yes.
I will go after the AG. That
I dare not, Malas, I dare not. Especially if I have to visit Bangalore. No,
Yes.
I will move after the AG. The reason was there is a whole cabinet note, there is a whole AG opinion that he alone
Yes.
can deal with. So let him deal
Yes,
with it
sir.
at some length. Well, my other problem is, I have a intention to make a comprehensive thing for 4 or 5 council who have argued against. So I'll put it
Yes,
all
sir.
together. So we'll fix up the date on the date after Mr. AG finishes.
No,
Then the dates will be clear.
You finish it on Thursday. Monday, I will take.
Your Lordship may have it because I need that weekend, Manoj. Your Lordship, Monday. I'll
Because
take
I
it
will not be able to come on Monday.
before-
Yes, so we'll, as we did the other day, we'll start at 10:30 and finish it off on that day. Whenever you say, not
No,
too
well, it's-
fast, sir.
My learned friend, I believe, is asking for Monday. So I'll do it shortly after that.
The request is this, Manoj. At least I'll have the weekend to just prepare. That's the only thing. Just one day, Manoj.
No,
6
don't-
or
Don't, do this during festival. ಮುಂಚೆನೆ ಮುಗಿಸ್ಬಿಡಿ.
No, the only thing is I'll just take a couple of hours before
Couple of hours.
before the petition commences, Manoj. So therefore, your Lordship may kindly fix a date, Manoj, after 9th or any other day.
That's true. We'll take it on 5th, Nimdo. You finish on 5th, whatever you say, then senior council, I'll take it on Monday at 10:30.
Look, I can't do it on Monday in any case. Your Lordship may give him some time. I'll do it little later after Monday. I was thinking of longer after him, but since Your Lordship is asking him to do it on either 9th or 5th, I'll do it after the 9th. I've checked up my dates. I'm in some difficulty.
Tentatively, what date, sir?
Well, it's frankly, I would like the working Saturday, which Your Lordship has advertised in the calendar. I know it's too far away, but I could do the whole day and finish it. That's my first request. I'm in Your Lordship's hands. It will suit everybody. We'll all spend the whole day and finish it off. And I'll put it together. That's on Your Lordship's calendar, That's what I thought I would do.
Let me see.
And that's why my learned friend can argue on 9th,
9th.
I know, I'm sorry that it's a little difficult before that. That's why I was saying.
If your Lordship, that means I think
No, this issue shouldn't stretch too
then
long.
I'll do it on 9th and I'll complete it, Manoj. 2:30, Manoj.
That's okay.
9th and 21st, Your Lordship may keep it, We'll finish both of us. Lordship will take it.
21st is too far, sir. This side of so we have vacations from 1st of October. 2nd of October, rather.
No, of course, there's no question of taking it beyond vacation. I will finish it in that one day.
No, not beyond vacation, but should also finish. I should write. Volumes after volumes are given. And AG is now saying he'll also give volumes.
No, I'll rely upon the volumes, I said.
And raise your volume. Yes.
That's just so
Can it be on 13th, sir?
No, then if it has to be, it'll be on 12th is better
12th,
than 13th.
yes.
But can I ask your Lordship to have a review petition on 9th after he finishes?
Review petition?
Reconsider.
From my
the
side,
date on the
Reconsider,
date.
yes, sir.
Reconsider.
Anyway, at the moment, your Lordship put it on 9th and 12th. But in case there is some difficulty, your Lordship may keep in mind 21st. Otherwise, 9th and 12th for the time being. 9th for him, 12th for me.
One today's for 2nd.
2:30, Manoj. Then we'll.
You need a week.
Anyway, I'll do it on 12th. My slot, let it be 12th. Whatever your Lordship adjust with the
Because
AG.
we have stalled the proceedings
Understand.
there. It's not.
No, 9th,
Correct.
2:30, I'll complete, Manoj. I'll not take much time.
Yes. Then we'll take it on 9th at 2:30. No further adjournment there.
No, I'm seeking for 2:30 itself. I'll complete it.
Yes, but
And 12th, your Lordship will review it that day. It may be earlier even. Before 2:30, I get enough time to cover. It may be pre-lunch little bit
Sorry,
and then
sir,
covering the afternoon also.
your voice is not.
On 12th,
Ah,
on 12th, your
Ah.
Lordship may want to start a little before lunch also, so I get more time.
no, whatever time you say, we will.
Yes. So on 12th, I'll do it. After you finish on 9th,
Then
3 days
12th, if
I'll
you're
do it.
present, we'll finish it off.
Yes.
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 Then we'll keep
Yes.
9th for the
I'll
AG
complete
submission and 12th, we'll finish it on 12th. Yes.
Obliged. Deeply obliged.
Yes. Heard so and so, Marty. The learned Advocate General seeks a week's time to make his submissions. List the matter on 9th at 2:30 p.m. ಅದನ್ನ ಅವತ್ತು ರೆಕಾರ್ಡ್ ಮಾಡೋಣ 12th interim order subsisting granted on 19/8.
Grateful to my Lord.
Yes. For the time.
Deeply obliged, brothers.
Yes. Hey, one matter there.
Grateful.
Yes. In the lighter way, sir, don't mind anything. Whatever. The monotony should be broken.
Manoj?
Monotony
Of course, of course,
big case should be broken.
of course. That is how Manoj, Julius Caesar also came.
Yet to Brutus.
Yes, my lord. Plutus was an honorable man.
You too, Brutus. That's what I said.
Your brother had his eyebrow.
That's what I said. You too, Brutus. There's one matter which is
Sorry.
put at 2:30.
Grateful.